Good afternoon. This is John Richardson speaking with you from Toronto, Canada. And today I am joined by Tait co-founders Karen Alpert in Australia and Laura Snyder, citizen of the world. And this is what I anticipate to be the first of a series of podcasts, discussions by Tait members, among Tait members, to talk about the important work, writing, and research that Dr. Laura Snyder has been engaged in for the last at least year, perhaps year and a half, maybe 2 years, maybe longer. But it's an amazing body of work which has appeared and continues to appear in different formats, academic journals, etc. But what she has graciously done is broken down her extraordinary research into a series of things that she calls working papers, which have been posted and are available on the Tait website. But what we thought we would do would be attempt to bring these papers to life in a more retail sense by devoting a podcast to each one of these working papers and gradually help people understand the problems with what Laura defines as nationality-based taxation, the history, what's wrong with it today, and the road forward in how to get rid of this. Welcome, Karen. How are you today?
Doing fine. It's a lovely morning here in Australia.
Oh, yeah, that's right. Different time of day. Well, Laura, what's happening?
Different day, even.
Different day, yeah. You see, what that tells us is that this problem of U.S. nationality-based taxation is a worldwide problem. And I think it would be safe to say, and perhaps we start with this, that the truth is the sun never sets on the injustice of U.S. nationality-based taxation. Laura, would you agree with that?
I would definitely agree with that, John.
Funny, I knew that. All right. Well, first of all, where can you find these papers? Because I know that after listening to this discussion, the first thing that all listeners are going to want to do is go and read the original working paper. So the answer is that you will find these things, or at least links. Okay, you can access them. I think that's a better word. You can access them on the Tait Now website, which is seatnow.org. That's SEATNOW.org, which means stop extraterritorial American taxation now. And I would highly recommend that people spend some time at that site. Karen?
Yeah, I was just going to say that the working papers are a menu item on the left. If you go down on the left, there's a Tait working papers is one of the menu items, and then it lists all the working papers. You can work your way through it that way.
And we hope that right now there's 16, and we hope that that Laura continues with this, and hopefully part of the reason for this podcast today is that she goes to bed tonight and dreams up a working paper number 17. But we'll start here with the first one, and I almost feel as though we should call this podcast perhaps Genesis. Where does this problem come from? What's the first sort of historical recognition of this as a problem? Laura, do you want to get us started with that?
Well, I think where you're going with that is the 1924 U.S. Supreme Court decision of Cook v. Tait. Is that where you're going, John?
Well, I had no idea where to go, but I'll take it, Laura.
This decision is cited definitely by people who support the current system. They will say, since 1924 U.S. Supreme Court decision Cook v. Tait, we know that it's constitutional to tax overseas citizens, and basically people will throw that at you anytime you object to the system or suggest that it might be unconstitutional. Surprisingly, it's not only the people that defend the system, but even people who are not defenders of the system who will also cite Cook v. Tait as justifying the current system and the grounds on which they will accept that it's constitutional. It seems to have occurred to no one to question the real value and continued applicability of Cook v. Tait, given the massive changes that have happened in a century now, both with respect to taxation, with respect to citizenship, with respect to the evolution of equal protection. Everything has changed in a century, and yet people still throw out this Cook v. Tait decision that was decided when Plessy v. Ferguson was actually the law of the land.
Now, Laura, I think that's a great start, and I get the sense that you find the decision objectionable. But, my observation about American law and scholarship is the older the decision, the less relevant it is to contemporary events, the more justifiable it is. Would you agree?
Well, when you said, I object to the decision, I would more characterize my feeling about the decision as, at this stage, it's just not a relevant decision. It is relevant in that people still argue that it's relevant, but if you really look at what's happening, you'll understand that Cook really doesn't explain and doesn't answer what's happening today.
Okay, well,
Well,
obviously,
that's because the world has really moved on since 1924, hasn't it? It's been almost 100 years, and things don't stay the same. Citizenship hasn't stayed the same. The tax code hasn't stayed the same. And so we're talking about a completely different world now than we were in 1924.
well, don't you think that an old decision, 100-year-old decision, I mean, in January, it was decided in May of 1924, I believe, we're actually coming up to the 100-year anniversary of Justice McKenna's decision. Should we schedule a special podcast on that day? What do you think, to celebrate the 100-year anniversary of that? Well,
I'm not sure celebration is the right word. Go ahead, John.
memorialize it.
Market, yes.
Well, now, Karen, you make a couple of points here. You say, well, citizenship has changed and taxation has changed. And why don't I invite you to pick one of those two things to talk about, either citizenship or taxation, and how.
Okay, so Laura has this lovely table in the paper that talks about the difference in taxation and the economy between 1924 and she's got 2019. So in 1924, the average household income was just over $2,000, and the filing threshold was, to $2,500 for a married couple. So we're talking about people with only above average income that even had to file income taxes in 1924. The exemptions were such that a married couple making $2,500 paid no tax. So in order to be even caught up in the US tax system in the 1920s, you had to be maybe not the 1%, but substantially above average in income. There were 7 million returns that were filed, and the average income per return was $3,500. So contrast that with 2019, where the average annual household income was almost $69,000, and the filing status threshold was for married filing joint was $24,000, which is much lower than the average. So you say there maybe 3/4 to 80% of people would be required to file a return.
Yeah, I think what one of the more telling things in this chart to me is that in 1924, about 30% of households filed a return. In 2019, 130% of households filed a return. So, you've gone from a system that affects only a third of the households to a system that affects households more than once, the same household more than once. So you've gone from a system, yeah, that affects a much smaller number of people, incomes at much higher levels than what you see today. So it's just those numbers tell you, you know, that you've just got a lot more people
Well, the
that are
tax
affected.
system has become a lot more pervasive.
Yeah.
Everybody is affected in 2020, 2024. Whereas, you had to be relatively well off to even have to worry about a tax return in 1924.
But
And then
surely,
The complexity of the tax code has grown exponentially over that time period as well.
So
Karen,
that's on the next page of that, because you're looking in
Yep.
the working paper number 1.
Uh-huh.
So page 5 has those numbers we just talked about,
Right.
and page 6 continues that chart and
Mhm.
and tries to explain in how it is more complex, in what
Mhm.
ways it is more complex. Do you see that?
Yes, yeah. Controlled foreign corporations, retirement accounts, punitive taxation of foreign mutual funds, phantom gains. All these things that have been added to the tax code since 1924 that make it a completely different experience for Americans living abroad.
well, how about
Yeah.
America living in the United States?
Well, that too.
It's a completely different thing. My impression of it is that in 1924, it affected a relatively smaller number of people, which it clearly did, but also that it was a much simpler experience.
Well, you didn't have to worry about controlled foreign corporations. You didn't have to worry about any kind of special reporting or penalizing taxation of retirement accounts or of foreign mutual funds. You didn't have to worry about phantom gains. You didn't have anything like FBAR or FATCA to worry about what's going on with your bank accounts. You didn't have an expatriation or an exit tax. You didn't have a fee to renounce citizenship. None of that, absolutely none of that existed in 1924.
But surely, Laura, the community of tax academics would regard all of these things that did not exist in 1924 but do exist today as advances in civilization, right? As good things.
Yeah, I don't see it that way, John.
No, I see. Okay. All right. So what we've got here, all right, is not only a completely different system of taxation, but frankly, a completely different idea of what taxation even is.
Right. A much more intrusive system in the current era than back in 1924.
Okay.
And I think maybe as a bridge to the citizenship issue, I think all of these penalizing aspects of the system, or far more complicated aspects of the system, you have to understand that these aspects of the system apply to people who are U.S. citizens, U.S. nationals living outside the United States, not to anyone else living outside the United States. So if you're a U.S. national, you have to deal with the CFCs, you have to deal with the foreign trusts, you have to deal with the problems with the mutual funds, et cetera, et cetera. All of these penalizing aspects, no, John, they do not promote civilization. They are highly discriminatory and penalizing, and they target specifically U.S. nationals living outside the United States.
Okay, so obviously both of you would agree if I were to say that the U.S. absolutely, positively, upside down, sideways, and diagonally imposes a more punitive system of taxation on U.S. citizens living outside the United States than inside the United States. Would you agree with that?
Yes.
Well, it's also a system that's more punitive as compared to people who are not U.S. nationals and living outside the United States.
Okay, so really, U.S. citizens abroad are sort of they're at the bottom of the food chain in terms of fair treatment. Would you agree?
Obviously.
Okay, so clearly we've had massive evolution of taxation in so many ways, so many ways. But we've also, as Karen said, have had major changes in citizenship. And
Mhm.
Laura, you want to carry the ball with that one? I mean, how's the concept of citizenship changed since 1924?
So in 1924, it was very easy to, if you lived overseas, it was very easy to lose your US citizenship, whether you wanted to lose it or not. Um, and so table 2 of the first working paper has a list of all the ways that people did lose their US nationality automatically if they lived overseas in 1924. So if you acquired citizenship of another country, if you naturalized another country, that meant automatic loss of US citizenship. If you were a naturalized US citizen who lived outside the United States for a minimum number of years, if you lived in the country where you came from for 2 years, or if you lived in another country for 5 years, automatically you lost US citizenship. If you're a woman who married a non-US citizen and lived overseas, either for 2 years in the country where your husband is from, or 5 years in another country, you lost US citizenship. And if you were a child, when you turned 18, you had to go into a US consulate and declare your intention to reside in the United States and to retain US citizenship and take an oath of allegiance. And if you didn't take those active steps, then you also were considered to have lost your US citizenship. So basically, if you were living overseas in 1924, if unless you were if you were a woman, you better not marry a non-US citizen. Otherwise, you needed to be a natural born citizen who did not naturalize in another country. And what was the other word? I can't remember what it was. But basically, the gist is today, the only way you can lose US citizenship when you live overseas is by formally renouncing US citizenship, going into a consulate and making the declaration and paying a very extensive, a big fee, $2,350, which I know they've announced that it's going to be reduced, but I haven't seen a date for when that's going to happen. And potentially pay an exit tax. Whereas in 1924, there's just a multitude of things that could get you could lose your citizenship. And actually, after 1924, in the 40s and the 50s, there were 2 Immigration and Naturalization Acts where they even expanded how you could lose your citizenship. If you deserted the army, if you voted in a foreign election, those different things would also get you to lose your citizenship. So what you have is, on the one hand, from 1924 to today, you have a tax system that has absolutely exploded in terms of who it affects and how it affects them, in terms of the people that are affected by the system and the types of laws that affect them and the complexity of the laws. And on the other hand, you have citizenship, which has gone from a relatively small number of US citizens living overseas on a long-term basis, since so many of them just lost their citizenship, to now basically anyone with US citizenship who lives overseas is going to retain their citizenship unless they take big steps to renounce it. So you've got this exploding tax system, and also want to say exploding citizenship, but certainly an increased number of citizens living overseas.
Okay,
So more people affected.
Okay, sure. So would you say that 100 years ago, the United States didn't have a tax system, other than being subject to it, that affected Americans abroad all that much, but they punished them by basically revoking their citizenship? Today it's the opposite. Say, oh yeah, sure, you can keep your citizenship, and we're going to punish you through the tax system, right? So
Yeah.
either way, Laura, it seems to me that it would be U.S. government policy to punish its citizens abroad. Would that make sense? They're just doing it
Yes, and using citizenship to do that.
Yeah.
Using it in different ways, but yeah.
I mean,
based on nationality, American nationality.
it's very interesting, right? They used to do it. They used to punish them through the nationality route. Today, they punish them through the tax route. How come they can't punish them through the nationality route anymore, Laura?
Well, they shouldn't be. They are, but they shouldn't be. Well, this is
What's that case? What's that case that caused all the problems?
with nationality.
Yeah.
Well,
Tax
there's multiple.
Ephorium.
Sorry?
Ephorium.
Yeah, the Ephorium
Oh.
case, yeah. Which,
That was
which meant that Congress couldn't write all those rules that stripped people of their citizenship.
there was there was Snyder, there was Ephorium, and there was the one with the deserter. What was, I can't remember the name of the case. I have to look
Terrazas. There was Terrazas. That's later, though, I think.
Yeah.
That's 1980, right? So we've got the two really big ones, right? The Snyder case was decided, if I'm not mistaken, on the basis that was an equal protection argument. Okay, that essentially said no. The government, for the government to strip that woman of her citizenship because she moved back to her country of origin or whatever, violates equal protection. So that was interesting. Okay, in the sense of the tax fallout after that, but really, I think it was the 1967 decision in Ephorium, wasn't it? Okay, that essentially says, bottom line, that hey, what Congress has been doing since the beginning of Congress has been unlawfully stealing people's citizenship, right? Saying no, citizenship, at least 14th Amendment citizenship, anybody born or naturalized in the United States, has a constitutional status that prevents the government from just taking it, right?
Yes. Well, there was. I'm trying to find the other one with the guy who deserted. What was the name of that?
Vance versus Terasis.
Sorry.
I think it's Vance versus Terasis.
That sounds. Oh wait.
All we need is Ephorium.
Trope Dulles. That one.
Well, so Ephorium, right, was what was the seminal case in elevating citizenship to constitutional status. The Snyder case doesn't do that because the Snyder case doesn't say that you have a constitutional right to citizenship. What it says is that if the government is going to strip people of citizenship, they can't do it in a way that violates other parts of the Constitution. I think that's what that case says. But I mean, Ephorium is huge, right? Citizenship belongs to the individual. Congress cannot do things which result in the forcible destruction of citizenship. Isn't that what that case says?
Yes, there was. Okay, yes, Ephorium was the big case that after that was when the State Department finally accepted that finally just decided they're not going to take this position anymore, that when Americans living overseas asked to renew their passports, they were going to renew their passports or at least not claim that they weren't citizens anymore. That was the case that kind of tipped the balance. There were a couple cases before that, and the one that sticks in my mind is the 1958 decision of Trope v. Dulles, which was a soldier was convicted for desertion, and during World War II, he was in, I think, Morocco or something. And when he applied for a passport later, he was told, no, you desert, you lost your citizenship. And this is when Earl Warren said, he was echoing Hannah Arendt, and he said, when you deprive someone of well, in this case, denationalization, that this is a total destruction of the individual's status in organized society, that, depriving someone of citizenship, a form of punishment more primitive than torture, where it destroys the individual, their political existence, that was centuries in development. And, he talks about how citizenship is, the expatriates lost the right to have rights. And so you have to see, ultimately, there is, a series of decisions that Chief Justice Earl Warren was responsible for in the late 50s and into the 60s. But yeah, I think Ephorium was the one that kind of crowned all of that, and where I think the State Department finally said, right, I give up, you win.
Well, Ephorium is the case that opens the floodgates, basically, right?
Yeah. It was after that case where you saw the number and basically that was when the number of people losing US citizenship by default basically plummeted to, today basically zero.
Actually, it wasn't until Vance versus Terasis in 1980 that as a matter of sort of just historical record here, the State Department actually did continue stripping people of their citizenship after 4M, presumably reading it as applying only to voting in a foreign election or something like that. But it was in 1980 that the Supreme Court essentially read, well, Congress and the administration, the Riot Act, and affirmed the 4M decision. And what was interesting was, if you look at the historical development of this, it was not even then until 1986 that the Immigration and Nationality Act was amended in order to include the language expatriation act with the intent to relinquish U.S. citizenship. They didn't even, bother to change the law. And then I think it wasn't until 1991 that the State Department actually adopted an administrative policy that these expatriating acts were not without evidence of intent to relinquish reasons to try to strip people of their citizenship. But what we've got here, okay, leaving aside the history, right? What we have that's interesting is in 1924, a relatively, compared to today, benign and simple tax system that probably would not have interfered in the lives of Americans abroad a great deal. Didn't have to, because the nationality laws that they were using to strip people of citizenship did that for them, right? I mean, that was how they expressed their hostility towards Americans abroad, right? Okay. Then we go 100 years later, and of course, we have 4M along the way that has made it very difficult to lose U.S. citizenship unless you try to renounce, and a much more complex tax system. So now Americans abroad are punished through the tax system, right?
Yeah.
Exactly.
Yeah.
I mean, it's quite interesting. I mean, this is one of the points that I think you made, Laura, in your work, which I think you're right, is that I think that the U.S. government has a lot of hostility towards Americans abroad. Actually, if you look at all this legislation, I mean, so many of these new pieces of legislation have come in as revenue offset provisions, et cetera. So I don't know. What are your thoughts on that, Karen?
No, yeah, I agree. It's not always feasible to live a productive financial life outside of the U.S. as a U.S. citizen. Depends entirely on what country you're in, but for many, I mean, this is why we see the renunciation numbers as high as they are. Because people are acknowledging that they can't be both the U.S. citizen and a contributing member of the economy where they're living.
Well, they can't be a tax compliant U.S. citizen.
Exactly,
That's
yes.
the problem. And what I've seen over the years is that, for many years, as there wasn't a huge awareness of the requirement that U.S. citizens abroad file tax returns. But what I've seen is that filing is often the first step to renunciation.
Exactly.
I mean, because they realize that, oh my God, they just can't manage it, sort of thing. Well, I sort of see the Cook versus Tait decision as being sort of Genesis, right? If we were writing a great book on this, which really is the beginning. And I guess one thing that I think is interesting, I don't know how relevant, but I've always found interesting about the Cook versus Tait decision. It was written by Justice Joseph McKenna, who had actually had a serious stroke before the case was heard, and writing the decision, and was basically had to sort of, step down after. I don't know if that would have had any impact on it or not, but it is interesting that the decision, Cook versus Tait, was clearly not written when Justice McKenna was sort of at the top of his game, right?
Yeah.
So what do you think, Laura? Should, I mean, let me ask you this question. I mean, obviously, all of us, anybody in seat, probably anybody in the world who actually understands the decision would be hostile to the decision. But do you think that nationality-based taxation in and of itself is unconstitutional, or do you think it depends on what the nature of the taxation is?
The Supreme Court has been very clear. This has occurred after the Cook decision, in the century since the Cook decision. Again, I repeat, Cook was decided when Plessy v. Ferguson was the law of the land, when it was actually considered constitutional to discriminate based on race. Of course, that, we've seen, multiple Supreme Court decisions over in the decades since saying you not only can't discriminate on race, but also you cannot discriminate based on nationality. And these are considered, those are the violations of equal protection that are subject to strict scrutiny, as in they are considered by definition to violate the 14th Amendment, unless you can show a compelling governmental interest and that the policies are narrowly tailored to comply with that compelling governmental interest. Otherwise, it necessarily is unconstitutional. If you identify people based on their nationality and you treat them differently from people of other nationalities, this is by definition a violation of the 14th Amendment Equal Protection Clause.
Oh, Laura, you put that, and of course, I've read the things you've written about that, so I'm used to the the cluster of words that you're using and that sort of.
Sorry.
No. I think it's a very descriptive and very good cluster of words. But as you were saying that, it reminded me of the Moore decision. Now, we in SEAT, SEAT has submitted an amicus brief in the Moore case, as you may know. And one of the points that is in the SEAT amicus brief is I think really aimed at that the transition tax, mandatory repatriation tax, is not exactly narrowly tailored, right? I mean, they could have left individuals out of it, couldn't they?
They could have left all individuals out of it. They could have left individuals living outside the United States out of it. Yes, they definitely could have. And they could have done it not only when they adopted the law, the Tax Cuts and Jobs Act, but at the moment of regulation. Multiple people appealed to the Treasury Department to develop regulations that would exclude individuals, and the Treasury
Or
Department
small
denied.
businesses. They could have.
That's right. That's right.
They could have put a dollar limit on the value of the business as a whole.
That's right. There were arguments for a de minimis exemption. Yeah, that's right. They could have done both of those things, John.
Right. So, I mean, certainly, even if one could take the position that citizenship taxation per se is not unconstitutional, surely it can be applied in a way that it is, because it's not narrowly tailored and discriminatory, right?
Well, if it's not narrowly tailored, if it's discriminatory, it's unconstitutional unless this is the way the Supreme Court sets up what is strict scrutiny. That's why I use those terms, because that's the terminology used by the court and used by anyone, academics who discuss in this area. So I was trying to use that terminology. But basically, discrimination based on race or nationality, and these are intricately linked, race and nationality. It's very difficult to separate the two. So you have to understand that nationality is as bad an equal protection violation as discrimination based on race, because they're for all intents and purposes the same thing. And so what the Supreme Court has interpreted the 14th Amendment to say is you cannot discriminate based on race or nationality unless the government has the burden of showing a compelling governmental interest and that the policy is narrowly tailored to serve that interest. So you know, you have, if you wanted to speak about this in terms of the mandatory repatriation tax, well, if you look at what the interest that's been expressed in terms of why that tax is needed, well, that it has nothing to do with individuals. Certainly has nothing to do with individuals living overseas. You know, they talk about how multinationals have accumulated income outside the United States that should be repatriated to the United States. Well, nobody said individuals, Americans operating small businesses outside the United States, were a problem in this context. Whatever they're accumulating in their small businesses was never intended to be repatriated to the United States. No one said the individuals were the bad guys in this context. No one said the law was ever even intended to target them. So, you know, by the terms of the government itself and how they've described this tax, individuals had nothing to do with it, and it's not narrowly tailored. It encompassed people that didn't need to be encompassed, and also small businesses. You can make the same argument for small businesses.
Mhm.
Well, very interesting points, very interesting points. Maybe we'll close out. I'll ask Karen a question. You know, we listened to Laura talking about, you know, this discrimination based on nationality, small. I mean, is it possible for the US to government run a tax system effectively that doesn't discriminate against somebody?
Look, I think it's possible. You got to keep the tax system within your own borders.
Now that is a thought, and I think maybe we will end today on that note. Well,
John,
Laura,
I'm sorry, you got to follow up to what you just said.
Which
There
may-
will always be laws that will discriminate in some way. The question is, how do they discriminate? And the issue here is when discriminating on basis of race or nationality. That's something you are not allowed to do.
Laura, I've got a question for you. Do you think it's time to stop extraterritorial American taxation now?
Yes, it definitely is time.
On that note, I'd recommend that everybody visit our website at seatnow.org. Well, this has been great, and this is only the first of our ongoing series of podcasts to discuss seat working papers authored by Dr. Laura Snyder. Well, thank you very much. Thank you
Thank you,
very
John.
Thanks, John.
much. Okay.